have 8 clauses at a title. I invite questions. Clause 1, Member for Ghana.
Thank you, Deputy Speaker. I'd like to ask a question in relation to the connection between the powers under this Act and the federal powers under the Biosecurity Act, which there was some discussion federally about those powers being enacted yesterday in which the federal government might be able to detain people. And just wondering if the Minister can outline what the differences and connections between those acts are, and are there how they might be coordinated between those two pieces of legislation at the state and federal level.
Minister.
I thank the member for the question. My understanding is that fundamentally the state laws and the powers that we're talking about are very much about containment of cases that present within South Australia and those risks. The federal laws apply very much more to what's happening at the borders and stopping more to do with dealing with the risks of people as they're coming into the country. But inasmuch as there is a connection and coordination, the Australian Health Protection Principles Committee, I understand, is meeting regularly, and I believe that this is a topic of conversation. The question that the member has asked is one that, in relation to particularly connections between the legislation, I believe is one of the matters for discussion in that body.
Member for Ghana.
Thank you, Deputy Speaker. My understanding is under this Act there's a public health emergency plan for the state, and that includes a number of triggers that would happen, one of which would be the declaration of a public health emergency. Wondering if the Minister can outline if any consideration has been given to such a declaration, and if not, what would the triggers need to be for such a declaration to be made?
Minister.
Has consideration been given? Well, public health officers, as these matters have been discussed, are obviously aware of the triggers as described by the member opposite. The current focus of their work is on containment, and my understanding is that the requirements to do that work is capable of being met within existing resources. The member asked what would potentially trigger it, and just to be out of an abundance of caution, I'm just going to double check with advice. So yes, if extra resources were needed over and above what is currently capable of being met, then that would be, for example, a trigger to deal with the management in that circumstance.
Member for Ghana.
Thank you, Deputy Speaker. And I appreciate that the Minister in his second reading speech said that a table or comparison of state jurisdictions would be provided. I'm just wondering, bearing in mind that the full information will be provided, is the Minister or his advisor aware of any other state that has the power to detain somebody or to issue orders for somebody who could have potentially been exposed in the way that this is now extending that out in this Act?
I'll try and describe the information as best I understand it. Effectively, different public health legislation around the country describes these types of risk in different sorts of language. So it's not, in effect, it's not written up in other law in exactly the same way as it is in South Australia. So in terms of what the member, I think, is trying to capture in the question that he asks is the category of people, are the people who are captured by the new category of people for whom these powers would then apply to, the could have group, are they captured by similar legislation in any other states? The answer is yes, but it is potentially described in different ways. And as as I mentioned in the second reading speech, I would provide further information to the member by taking the question on notice. Perhaps I will, to satisfy the form of the House, I will take this question on notice formally here in order to fulfil the commitment I gave earlier to provide full information to the member and to the House.
So the question, yeah, you've had three. Question before the chair is that clause 1 stand as printed. All those in favour say aye. Those against say no. That's carried. Question 2, Member for Ghana. Okay, and your next question to 3. Okay. So the question before the chair then is that clause 2 stand as printed. All those in favour say aye. Those against say no. That's carried. Clause 3, Member for Ghana.
Thank you very much, Deputy Speaker. In relation to the powers that the Chief Public Health Officer has under this section and also in relation to other sections in the bill, can those powers be delegated to other people? And if so, how many current delegations are in place for the Chief Public Health Officer's powers?
The answer to the first part of the member's question is yes, they can be delegated. In relation to how many current delegations are in place, I'd like to take that question on notice and we'll bring back a response to the member in the House.
Member for Ghana.
Thank you very much. There was some discussion in the other place in relation to this power for somebody to undergo testing and also in relation to the other sections about no longer requiring written notice, and oral notice could be provided, which would follow then within 48 hours with a notice in a written form. But then the Act says that the failure to serve a notice doesn't affect the validity of the order. So just wondering if the Minister can outline if there is this clause saying that we don't need to follow up with a written notice, it doesn't affect the order, why have the section saying that you do need to follow up if it doesn't matter anyway?
Hey, I thank the member for the question. The advice that I've received is that this is indeed a standard way of expressing a clause around an oral order. The caveat in relation to an oral order in not just this legislation, I believe, but potentially others, the caveat in relation to the order still standing is necessary to mitigate against a risk if there was some sort of interruption to the conduct of the written direction. But it is, even with this savings provision, as I'd probably characterise it, it is certainly the intent that a written order be provided, and that is important so that to remove any ambiguity, to remove any doubt, so that the person who is receiving the order has every understanding of why the oral order has been given.
Member for Ghana.
Thank you. And to clarify what the government's, I guess, interpretation or definition of an oral order is, would that involve an order issued by telephone or some sort of other carriage or internet service?
Okay, the advice I have that it is certainly our intent. The intent is focused on it being a direct instruction. That said, it is likely, according to advice, that a telephone instruction or potentially a Skype oral order would be allowable under the law, but it is certainly intended to be in relation to a direct instruction.
Question before the chair is that clause 3 stand as printed. All those in favour say aye. Those against say no. That's carried. Tick for 4. And where's your next question? 5. Okay. Thank you. The question before the chair then is that clause 5 stand as printed. All those, sorry, my apologies. Clause 4 stand as printed. All those in favour say aye. Those against say no. That's carried. Clause 5. Member for Ghana.
Thank you very much, Deputy Speaker. So in relation to the new definition under section 75(4)(a) of a specified place now involving a quarantine facility, just wondering, has the government given any thought to what quarantine facilities could be used in such a situation? I presume that there's nothing that the government currently houses as a quarantine facility. In fact, I think the Minister asked his advisor during our briefing if there was any quarantine facility, and I think the answer was no. But therefore, some other facility might need to be used. Is that part of the plan, that there is contingencies in place, or would it be that there would have to be a rush to try to find something?
I thank the member for the question. In relation to this matter, the question started as has the government given thought to what might be used. I mean, obviously, consideration is being given to this as part of the whole preparation process. And as I said earlier, the planning for a potential outbreak of COVID-19 is ongoing. It includes discussion with agencies and other jurisdictions, and the specific details would depend on factors including the severity and timing of the outbreak.
Any further questions? All good. The question before the chair then is that clause 5 stand as printed. All those in favour say aye. Those against say no. That's carried. Next question, member for Ghana. Clause 6.
Yes, thank you. Yesterday, the Minister undertook to provide for consideration what facilities outside our metropolitan hospitals are identified as quarantine facilities in the event of an outbreak. Can that information now be provided? My understanding is that the government is saying that generally it would be looking towards hospitals being used. But my understanding from a number of pandemic plans, etc., that there has been discussions of what for a pandemic flu would be flu clinics, or in this case, respiratory or fever clinics, and have those sites been identified as well?
Look, I thank the member for the question. Obviously, the Minister for Health in the other place provided some response yesterday, and I think that the answer to this question is probably, from my point of view, in this place, similar to my answer to the previous one. And if there is, to be clear, the direct previous one, that depends on the factors involved, and to the extent that I'll be able to provide any further information in the not too distant future, I will bring that back if it is appropriate to do so.
Fagana.
Thank you very much. Wondering if the Minister has had feedback in relation to the bill from the Australian Medical Association, and if not, then wondering if he could respond to the feedback that they've provided through to the opposition in relation to this bill. I think on the whole it's fair to say that they've given cautious support and hope that it be carried out in a calm and depoliticised manner, which I believe we've all agreed has happened. But they do raise some suggestions, including that suggested that the defined situations in which control measures be applied be tightened to a controlled notifiable condition with a pandemic potential. So obviously there's some controlled notifiable conditions that do not have a pandemic potential. And they've said a panel should be required to invoke such a power with at least 2 suitably qualified medical practitioners. The panel for which the individual is detained should be clear, and the period for which the individual is detained should be clear and for the minimal time to ensure effectiveness. There should be a robust, streamlined, resourced appeals process which should be accessible to all, including socially disadvantaged, which can be practically managed in the situation where an individual is detained. And they go on to say the need for respect for the individual and the manner in which they are treated should be emphasised, and the practical manner in which detention is to be enforced should be clear. So just wondering if you've had that feedback, and secondly, what's your response to those suggestions from the AMA?
I thank the member for the question. We appreciate what I think the member described as their support for the legislation, and indeed I express, if it hasn't already been done, the appreciation that we always have for constructive feedback. Obviously, as the member himself identified in the second reading speech, the bill does deal largely with existing powers in terms of some extensions to those, but we will obviously be very, very respectfully looking at these suggestions and from the AMA and other stakeholders as to how our laws or regulations, practices and policies can be enhanced. It's really important to note in relation to the specific point that the member has raised that in the existing arrangements significant appeal provisions do exist and indeed will continue to.
Member for Ghana.
Thank you very much, Deputy Speaker. And obviously, in the case where somebody is being detained, the health workers and the police, etc., who would be undertaking that work would be potentially exposed. And there was discussions in the other place yesterday about how to do that, including the need for personal protective equipment and making sure that staff were looked after, and also making sure that people were appropriately detained and making sure that that they were doing what they were meant to do. So I wonder if the Minister can outline what steps have been taken to enhance our capability in terms of personal protection for staff who might be doing this work? And secondly, has any thought been given to any monitoring devices, etc., for instance, presumably similar to what we would use in the correction system at the moment, that could be applied to people to make sure that they are following the orders? And I understand that the Minister said that he would seek more advice and come back on that today.
Minister.
I'm advised that people involved in the management of cases of the training have the necessary personal equipment. SA Health is obviously well and truly in a position where if there are further measures that need to be taken, then they'll be able to provide that advice. I think the Minister traversed some of this area in the Legislative Council yesterday.
For Elizabeth.
Thank you, sir. Just some questions on clause 6. I wonder if the Minister has received any direct feedback from the Police Association and whether that feedback could be tabled.
If the member doesn't mind waiting a moment, we're just double checking. Look, I thank the member for the question. SA Health continue to be in discussions with SA Police. I'm advised that the Police Commissioner has conducted a briefing with the Police Association. I don't have details as to the intimate details of that discussion.
Member for Elizabeth.
Yeah, my next question then is about the nature of detention itself, and it may be my lack of understanding of the original bill, but has the power... Obviously, an order is made, an oral order or otherwise is made, and then certain people are empowered with the authority to detain people, including SA Police, that's my understanding. Well, certainly that's the public statements, even though it's not mentioned specifically in this clause. I wonder if that power of detention, because I understand that there's powers of detention that the SA Police have in relation to warrants. I understand their powers of detention in relation to the Summary Offences Act. I just wonder what their specific authorities are and are they the same in the original Public Health Act as they are under this amended section, if you understand my meaning? Are they in the original 77?
Okay, 2011-2012, these powers have existed. The current legislation before the House extends the number of people to whom they might be applied, or indeed the oral direction being an opportunity for the direction to be more easily applied. So potentially, theoretically, there could be more people to whom it would be applied. The principle, as I understand it, is the same. And I think, as the member for Ghana said in his second reading speech, as I'm sure the member for the Minister for Health has said, most people overwhelmingly would respond to that oral direction in a sensible way. We're talking about people who are being given advice that's not just for the community's safety, it's for their own safety and their own health and their family's health. And most people overwhelmingly in our community, you would expect, would comply with an order from the Chief Public Health Officer.
For Elizabeth.
Yes.
Or their delegate, or the Chief Public Health Officer's delegate.
Just to clarify then, SAPOL have been included in that list of delegates since 2011-12? No?
I direct the member's attention to the existing Act, Clause 79, Subclause 10. In this section, authorised person means A, a police officer, or B, a person authorised by the Chief Public Health Officer to act as an authorised person under this section.
Thank you. Then perhaps you could clarify for me while we're here, when there's an arrest made or a detention made under a warrant, like in 79, and in Clause 7, there are stipulations about the use of force. The police can use any force. The authorised officer can use any force. I assume that the same rights and protections afforded by that kind of clause exist in 77. Because we're not just talking about the vast majority of people, as you say, who will comply with an order. Perhaps we're talking about some people who may, for whatever reason, not wish to comply with an order.
I thank the member for the question. Obviously, we trust that the vast majority of people behave in a rational fashion, and we make laws to deal with those that don't sometimes. I think the at risk of, I think the answer to the question was my advice is yes.
Now, Member Fagana, you've had 3 questions on this clause.
I thought I had 2 on this clause.
Oh, I've got you down for 3.
I'm happy to have another one.
Look, given,
look at this
given
spirit
the
of bipartisanship.
given the minister's amenity to this, you have the call.
Yes, I thought I kept one up my sleeve. I had, that's right.
Might have been a point of
It was
clarification.
very strategic. I don't think you answered the second one, but in any case. Understanding what you were saying in terms of the people who are authorised to order the detention and carry it out, obviously there would be an issue in terms of making sure that those people are appropriately detained. And I guess one of the issues that the Police Association have raised is that going to have to be the police who have to monitor these people and make sure that they are where they're meant to be in this quarantine facility? Or would you bring in security guards who would do that? And what is the plan for who would be looking after those people? And I guess one of the concerns the Police Association is that if it is the police who have to guard these people, well, that's a lot of people, a lot of police officers that you're taking off the beat to do that, and what's the impact upon their resources? And I guess likewise, if it's security guards who are doing it, then that might be something that needs to be planned ahead of time to make sure that they're appropriately trained, appropriately protected, PPE, etc., to undertake such a role.
As I understand it, the intention would be, in a general situation, to detain in a healthcare facility. So who is responsible in this situation would depend on the individual case, but I don't want to make a big issue out of it, but the member has himself acknowledged that we're not going to be talking about a significant number of people. The power in itself, we would anticipate, would be responded by the vast majority. When the member says it would take a significant number of police officers off the beat, as I say, it would be in a health facility. We might not be talking about police officers, and I don't think we're going to be talking about a large number of people. It's authorised officers under Section 43 of the Act may use their existing powers under Section 47 of the Act to be accompanied by assistants, which may involve security. And there are also powers under the Emergency Officers provision of the Act, Section 48, to be appointed by the Chief Executive of the Department. This may be individuals or a class of people, so there is some flexibility there.
Question before the chair is that Clause 6 stand as printed. All those in favour say aye. Aye. Thank you. All those against say no. That's carried. Clause 7, Member Fagana.
Supported. As of today, who are authorised officers under the Act? You've mentioned police, but who else is there?
I'm advised that there are state authorised officers who are essentially SA Health employees who fall under this category, and also local authorised officers who are essentially council employed environmental health officers who tend to fall into this category.
Member for Ghana.
So essentially they're the same authorised officers for health inspections as for dealing with these notifiable conditions.
For the sake of clarity, can I have the question again, please?
So you mentioned in your answer before that authorised officers are various SA Health people and environmental health officers from councils. So essentially is it the same authorisation for exercising powers under this Act to deal with food inspections as it is to deal with these notifiable conditions? There's not different categories.
There are two different types of authorisations.
Member for Ghana.
Have any warrants ever been issued under this Act in terms of Section 79?
Not that is coming to the mind of anyone in the room, but we will take that on notice to ensure that if there have been, we will be providing that information.
Member for Elizabeth.
Yeah, I just have one question, and it harks back to the member for Ghana's question on Clause 6 about resourcing and about the levels of police that might be involved, particularly police who might be involved in the detention and the impact that would have on their resourcing. I guess I want to put the question to you again, because I think that it is a good question when police detain people under the Mental Health Act, for instance, or when they are present when suspects are hospitalised, for instance, if they're injured, the police have to stand by. That does take them off the road for a shift or two. And I think, perhaps to clarify what the member for Ghana was saying, what I'm asking about is not lengthy periods of detention. What I'm asking about is the initial detention. So the order's made, the detention is made. If we are talking about a large pandemic, we have to. The reason we need to bring this in so urgently is that we have to anticipate something like that, or we have to acknowledge there is a possibility. Then, what discussions have gone on with the Attorney General's Department or with the police about resourcing in the case of a significant pandemic, whatever the correct word is? So there are large numbers of people being detained simultaneously. Are police expected to control those, and has there been any discussion about extra resourcing? Impact.
This bill is not to address that apocalyptic pandemic worst-case scenario that the member just described. This bill is focused on meeting our current and immediate needs. If the sorts of circumstances current and immediate potential needs, if the sorts of circumstances which the member has described, then that would trigger the issue that we were talking about before, an emergency management arrangement, which would be a different set of circumstances.
Question before the chair is that Clause 7 stand as printed. All those in favour say aye. Those against say no. It's carried. Clause 8. Any questions? Member for Ghana.
Thank you very much, Deputy Speaker. This is a clause that looks sort of minor, and obviously in the weight of the other clauses probably hasn't had as much attention. But I'm just wondering if you could explain what the rationale behind this clause is, because my reading of it is that currently the legislation says if I'm serving the Deputy Premier a notice saying that she needs to be detained, then she needs to be given that personally. Whereas we're now saying that I wouldn't entertain such thoughts, Mr. Member for Elizabeth, that it could be served on an agent of the person, so presumably a lawyer, etc. It could be left with the person at their place of residence as long as they're over 16, or it could be sent by post to the agent of the person at their last known address, which, in the circumstances in which we're talking, doesn't seem sort of a reasonable approach given the immediacy in which we would want that person to have the information to rely on Australia Post, as good as they are, to get it there within 3 to 4 days.
Thank the member for the question. As in a number of other things, obviously we're referring to the provisions that exist in the Act already. Obviously the first preference is always to serve it directly. The experience of communicable diseases staff, I'm advised, is that there are occasions where that is not possible, and that is why the Act anticipates and contemplates such a circumstance.
Member for Ghana.
Thank you. Well, I hope nothing has to be relied upon the Post to deal with this outbreak. Just last question from me is... Sorry? I don't think she is anymore, but no. That doesn't mean that... Even if she was, that doesn't mean they're not slow. Just last question. In terms of... You mentioned before that the authorised officers include the Council's environmental health officers. What steps have been taken, I guess, over the past month and a half since this issue of coronavirus has been brought to the public light and world attention, to engage them in this process, and also to educate them on what the additional changes that the government's seeking to make through this legislation? Because obviously, given they would have an important role, I would have thought it would be important that they know what the new powers and responsibilities would be under the Act.
Look, I thank the member for the question. Directly to it, SA Health has been in regular contact with both the local government association and indeed these specific officers that the member has identified as COVID-19, and our understanding of it has developed over the last little period. While that will continue, and in relation to these specific powers, the information will continue and the support will continue, we expect that it will be the SA Health authorised officers who would be the key parts of the government's response and support for our community in this space. These officers are also obviously identified, but it is the SA Health staff who will be the key players in this space.
No further questions on Clause 8. Then the question before the Chair is that Clause 8 stand as printed. All those in favour say aye. Those against say no. That's carried. The final question before the Chair is that the title of the bill be an Act to amend the South Australian Public Health Act 2011. All those in favour say aye. Those against say no. That's carried.